Good afternoon to those tuning in from Europe, and good evening to those tuning in from India and parts of Asia. Welcome to the latest webinar series by IDEX Legal, where this time we're focusing on providing technical guidance to the lawyer community. Now, I'm Vikas, Managing Director of IDEX Legal and your moderator for today. This latest series is in conjunction with international law firm Harrison Clark Rickersby, HCR for short, and the India partner firm, India Law Alliance. HCR is an award-winning top 70 UK full-service law firm that traces its roots back to 1796. India Law Alliance was established more recently in 2004 with offices in Mumbai and Delhi, and they're a cutting-edge boutique law firm focused on dispute resolution and corporate commercial work. Episode 1 of this series with HCR and ILA doesn't pull any punches. We start off with one of the most contentious regulatory amendments in recent times. Not easy to achieve given the depth of changes coming out of the legislature. Today we dive into the Arbitration and Conciliation Amendment Act 2021, which was passed into law on 10th of March this year and is the most recent intervention by the Indian Parliament on the Arbitration and Conciliation Act 1996. To dissect the controversy and implications of the recent amendment, we have a solid panel consisting of Ajit Mishra, partner at HCR. Ajit's a dual qualified award-winning corporate lawyer who has a strong track record in corporate and commercial law. He specializes in cross-border foreign direct investment laws and works with both UK and Indian companies, both to support their transactions and to advise on potential developments in their interests. Welcome, Ajit. We also have Anupam Dighe, managing partner at ILA. Anupam's also a dual qualified lawyer based out of Mumbai. He co-founded the firm back in 2004 with a vision to provide clients with quality services and high investment of time from lawyers. Kiran is our next panelist, Kiran Padalkar, also a partner at ILA. Kiran's a lawyer from Mumbai, obtaining his degree in law from the Government Law College. He's been an ILA since December 2013 and was promoted to partner in October of 2019. So welcome everyone. Welcome to this really important discussion on the recent amendment. Time's going to fly, so we're going to kick straight into some of the questions around the recent amendment. So Kiran, first of all with you. Can you just give us a background and glimpse of the history of the Arbitration Act, and also the latest amendment of 2021 to the Arbitration Conciliation Act of 1996? And as once you're kind of delving into that, also answering, what is the government trying to achieve with this latest amendment?
Yeah, thank you so much, Vikas, for this wonderful introduction. With great honor to be the panelist along with the peers of this fraternity. The modern arbitration law was enacted as early as in 1772. However, it was statutorily recognized as a form of dispute resolution for the first time when Indian Arbitration Act 1899 was enacted. However, the 1899 Act was only confined to the 3 presidency towns only, that is Madras, Bombay and Calcutta. But it was further extended to the whole of India. As the 1899 Act was inexpedient and more technical, so it got repealed and Arbitration Act 1940 came into existence. So 1940 Act was there till 1996 when the Arbitration and Conciliation Act 1996 came into picture. That is because after the economic liberalization in the year 1991, steps were taken to attract foreign investment, which required a comfortable business environment and ease of doing businesses for the foreign investors. And this is how the 1996 Act came into picture, and which covered both domestic as well as international arbitrations. As government of India wanted to make India as an arbitration hub for the foreign investors also, there have been several amendments to the Act of 1996, out of which the amendment of 2015 and the latest amendment of 2021 are the crucial ones. So let us go on to the latest amendment of 2021, which is in nutshell as it is that there is an extension to the section 36 of the 1996 Act, which includes the proviso to section 36(3), which says that the court shall stay the award unconditionally in cases where it is prima facie made out that the arbitration agreement or contract, which is the basis of the award, and the making of the award was induced or affected by fraud or corruption. And to be noted that this is effective from 23rd October 2015, which is the effective date of the 2015 amendment to 1996 Act. Then there is another amendment to this in this 2021 amendment, is that Section 43J of 1996 Act, which was introduced by the amendment of 2015, has been substituted, and the new section states that the qualification, experience, and norms of the accreditation of the arbitrator shall be specified by the regulations. And the Schedule 8 of the 1996 Act, which is interlinked with the Section 46, has been omitted. So the purpose to amend the Arbitration of 1996 Act, Arbitration Act 1996 by the government is to attract the investors, foreign investors to India, and also to make India as an arbitration friendly hub. Thanks, Vikas.
Right. Ajit, we're just going to move on to you on that, because obviously Kiran was then talking about, one of the intentions of the government is to make India more of a investment friendly hub. And for someone like yourself, you do a lot of cross-border work, you represent clients on both sides of both continents. What's your view on the latest amendment to the Principal Act? Is it something that's going to encourage kind of foreign investment to come in, or is it something we need to keep working through? You're on mute, Ajit.
I was on mute. Sorry about that. So thank you so much, Vikas, and thank you so much, everyone, for joining. Good evening. So the answer to your question is this 2021 Act, as Kiran mentioned, it has got two parts. One part is about stay of the proceeding in case there is a corruption or fraud which is involved. And second one is qualification of arbitrators. From face of it, it looks a bit restrictive in terms of when we can actually, the whole basis of our arbitration proceeding is that it should be fast, efficient, and court's intervention should be minimal. But in this case, on face of it, it should, if the losing party has got one weapon where they can actually approach the court and stop that proceeding or prolong the proceeding. Second one is about the arbitrators, qualification of arbitrator. But I see both things in a positive light. One is when you talk about arbitration proceeding or arbitration agreement, which is already tainted, it should not give any benefit to any party, because those contract itself is void ab initio. They start with corruption, and legally they are not binding. And if somebody is taking a benefit out of it, that should have been stopped. And I think the intention of this act is to stop that disadvantage to the winning party. So one aspect of that's very fundamental, which is if contract is or arbitration award itself is induced by fraud or corruption, it should not have any consequence in the legal society, okay? And nobody should take benefit out of it. Problem is that it has not been defined properly. What is arbitration? What is, I will say, fraud, how fraud has been defined, or how corruption has been defined. It has to be defined really well. And also there should be a bit of timeline within which court should react quickly rather than spending 5 to 6 years, followed by I will say, going for appeal to Supreme Court and all that. There should be a process in place where you actually come up with a solution. What constitutes, or what when you say allegation of fraud or corruption, what is the test for that? So I think onus is more on court to deal with those applications much more quickly. Similarly, when it comes to the arbitrators qualification, I think that's a step forward, and it's really good, where those parties can actually choose their arbitrator who has got the right skill set, and they can actually arbitrate the matter. So I think it's quite progressive on face of it, and actually it's quite progressive, but at the same time, there's a lot of work which is required to be done to make it actually operational and for the benefit of both parties. You're on mute.
I'm on mute now.
Yeah.
Which is why we can't wait to also get back to person in person. So, I mean, Anupam, we've heard from Kiran there in terms of dissecting, what the history of the Arbitration Act was, what's been the intention over the new acts that have come out, the amendments. Ajit's given a kind of perspective on the viewpoint of trying to make it more investment-friendly environment. There are pros and cons to what the government's been thinking and what they've enacted. What's your kind of view on the latest amendment, and how would you dissect the controversy around it?
Right. Firstly, thanks, Vikas, for the nice introduction, and thanks to all the panelists. I would just like to, take cues from the other panelists who have mentioned about, Kiran mentioned about the background, how the Arbitration Act evolved over a period of time. And, the whole background about it is that every time the legislature realized that the lawyers are ensuring that they get maximum work out of the legislation that is coming out. And, as we lawyers, litigating lawyers, we are either on the winning side or the losing side. Depending on that, we kind of try to drag the litigation. And that was one of the points which Ajit also said, that, we need to minimize the litigation time. But be it as may, we are very innovative lawyers, so we can have, holes in all kind of amendment that keep on coming. So the arbitration award, the whole purpose of amendment and reenactment of arbitration was to reduce the judicial discretion, which was otherwise available in the 1940 Act, and then subsequently it came it also percolated in 1996 Act. Which was not the intention of the legislature. They wanted to reduce the judicial intervention in the arbitration awards that were passed. Because what was happening otherwise is that once an arbitration award is passed, it used to go through the same process as a judicial decree of any district court, of any trial court would happen. People used to file appeals, and the appeal used to go on and on. So there was a point where people preferred not to go for arbitration because it was only adding one more step in a litigation that they would be faced with. And again, arbitration doesn't come cheap. If you have a panel of 3 arbitrators, it also used to cost a lot of money. So keeping this in mind, the whole legislative changes that happened over a period of time, right from 1940 to 1996, and we are in 2021, and that's the whole endeavor of the legislature, to reduce the discretion of the judiciary and make the process as smooth and as functioning on its own, without people having to interpret it in a different way. So I would say the whole crux of the current amendment that has come in 21 is to ensure that there is one more step forward to reduce the discretion which is available to the judiciary, or reduce the arguments that are available to the litigants which are coming in appeal. So as Kiran mentioned, the amendment talks of a compulsory or a mandatory stay in case of certain frauds or corruption which has resulted into the agreement or the contract or the award being vitiated. So earlier the situation was that if these grounds are taken up, the first point of argument was that first you had to make out a prima facie case to say that there has been fraud or corruption. The clause, the section 34, which allows the appeals to be filed against an arbitration award, only talk of a agreement which was a arbitration agreement being drawn by virtue of a fraud or corruption, made a ground to file an appeal. Now, in the section that has been amended, they have not only maintained agreement, that is the arbitration agreement, but also included the very contract, which is the basis of the dispute, or the underlying contract, as well as the award, which is passed up pursuant to the whole process of arbitration. So either of the three, if there is a fraud or corruption which has resulted into such agreement, contract, or award, then the section says that the stay has to be unconditional. So therefore, a discretion which was available to court, firstly, whether a stay has to be granted or not, and even if a stay has to be granted, can it be unconditional or not, is been the endeavor of the legislature is to remove that discretion from the judiciary. So judiciary just has to see that is there a prima facie case which of a fraud or corruption in case of the agreement, the contract, or the arbitration award. If they come to this prima facie, again I'm stressing here, it has to be a prima facie view. They don't need to examine any kind of evidence. They don't need to examine and go through any of the documents which were before the arbitration panel. They just need to come to a prima facie view. And if they are of a prima facie view, then they have no option but to give an unconditional stay. And that is where I feel will kind of expedite the whole process, or the arguments which otherwise go on to what should be the correct condition that could be imposed on the parties to go in for appeal. So the whole purpose of this amendment is to give some kind of a indication that what will happen next if you come and prove a prima facie case of fraud and corruption. The other purpose of this amendment, of course, the provisions of appeal specifically talk of if it is opposed to the public policy, or if it is against the basic notions or basic morality of the community, then an appeal can be preferred. And I'm sure fraud and corruption are the two things which are opposed to the basic morality. So the purpose or the grounds were available. But then you had to prove that there is a fraud, and fraud is something which is opposed to the basic morality, and therefore an appeal maintained. Now what has happened is that they have specifically introduced fraud and corruption. So it has been codified as one of the reasons which can result into the stay of the arbitration award, and that too unconditional. So as lawyers, that we had to labor our point to say that there is a fraud. Fraud is second point, saying that it is against the basic morality and therefore an appeal. So our labor has reduced, but I hope that the fees don't reduce with that. But yes, so to reduce the discretion is what I see the specific amendments have been brought in, and I'm very hopeful that this may sometimes what happens, people know that they don't have a case or the arbitration is against them. But just because there are certain difficulties of pursuing these appeals before the court, and the timeline that has been taken, which was mentioned by Ajit, for getting finality in this appeal, people tend to file an appeal and thereby frustrate the remedy, frustrate the benefit that is available to the winning party. By putting in these kinds of things, there are certain aspects which are coming into force, which will help to give certain certainties to the discretion which were otherwise available with the courts. And I'm looking at these amendments in a very positive way, especially for the stay, because I remember having arguments running into hours even for the basic prima facie case and stay in the courts. So with these amendments, the time taken should be reduced, at least at the initial stage. As regards the other amendment, which Ajit mentioned about the qualification of the arbitrators. So initially there was a specific schedule 8, which talks of what are the basic qualifications that that should be there for the arbitrators to be on the panel, or what should be the basic threshold for a person to be an arbitrator. So that has been removed. Though the section that has been inserted says that subject to the regulations that will come up subsequently, the arbitration qualification will be decided. Though the regulations have not been notified as yet, but as it stands as on date, is that there is no restriction as long as the person is of a sane mind and both the parties agree to make him an arbitrator in respect of their dispute. So that is how it stands as of now. So the restrictions which were there to select an arbitrator has got substantially reduced, which also means that a person can go even an international dispute. A foreign party may say that I want to have a arbitrator who's a lawyer in my country, though he may not be a lawyer in India and may not be able to agitate a point in the court of law in India. But in the arbitration, he can still be an arbitrator. He can still decide that matter. So that is something which could be a comfort issue for, let's say, a person coming from the UK feels that, okay, the person, if I have an arbitrator, at least on the panel, who understands how business is done in UK or how business is done in my country and how things are interpreted or how a mind of a businessman goes, it will be much beneficial to put my point forth, and he will be able to then convince the other panelists to understand that why a particular decision was taken or why a particular thought was there in the mind of a foreign party when a transaction was being entered into. So if you look whole in whole, yes, these amendments look initially that certain restrictions have been imposed, but I feel those restrictions or those codifications are something to reduce the discretion, to reduce the time. And I'm really hopeful that this is something which will help to take the cause of effective arbitration and effective resolution of disputes in India. Over to you, Vikas.
Super. I was actually going to ask that about, what do you think about what impact would it have on the viability of arbitration as an effective dispute resolution mechanism? But I think overall, you've kind of mentioned that while there are things to be ironed out with regards, like what even Ajit was mentioning, the kind of finality of defining what is fraud and corruption and who can be an arbitrator, but generally it's a move in the right step with regards to making arbitration a more easier to apply tool for managing disputes in the country. Kiran, we're gonna move to you then, just again on that key amendment around section 36 of the Principal Act, and with regards to how do you think the Indian judiciary system is going to look at that? And then also, again, what does this mean to India's overall desire to become an arbitration hub?
Well, I'm completely agree with Anupam's view that amendment to the section 36 is a positive amendment, because earlier under section 34, the award used to be set aside when the arbitration agreement was invalid. Now the legislature has added another tool to it, that if a contract, which is a basis, which is the main contract in which the arbitration clause is there, if that contract is induced by fraud and corruption, the parties can take a plea and seek a stay on the arbitration award. So earlier, see, the judiciary and even the courts have distinguished the arbitration agreement and the contract separately. The arbitration clause itself in the contract is a separate arbitration agreement, and the contract is a main contract. Even if the party takes a plea before the arbitrator in a section 16 proceedings that the contract is invalid or a void ab initio, still the arbitrator had a right to go ahead with the arbitration, and the parties were forced to the arbitration and the expenses pursuant to it. So because of this inclusion of a proviso to section 36(3), now the parties can take this plea that the main contract, okay, arbitration agreement is null and void or it's induced by fraud, but the main contract also can be taken as a ground that was induced by fraud and corruption, and the parties can take a plea before the court in a pending section 34 application as well, that even I had taken a ground before the arbitrator, but arbitrator had decided that the arbitration agreement is valid, though the contract is not valid. But now I can come forward and take a plea that, okay, the contract itself was induced by fraud and corruption. Therefore, the arbitration award has to be stayed. And this privilege is added in section 36 to the parties which can be taken up even if the section 34 is disposed of and the aggrieved party has gone to the Supreme Court. So even in the Supreme Court, if the stay is not granted to the enforcement of the arbitral award, the parties can take this plea and stay the arbitration proceedings and not arbitration proceedings, the enforcement of the arbitral award. So the parties have a chance, even if they have taken this stand before the arbitral tribunal, to take up till the Supreme Court. Further, so the courts are looking to it in a fashion that I would rather say the legislature has rather given more powers to the court to consider and clarify that ability of the court to examine new evidence or to engage a de novo assessment of evidence in the analysis of the arbitral tribunal. That is one. And further to consider and clarify the scope of fraud and corruption. Further, to consider and clarify the degree to which the conclusion in the award can be examined or differed with, and to consider and clarify the effect of failure to raise such allegation before the arbitral tribunal or in a court proceeding. So, the court can take a prima facie view that the contract or the arbitration agreement was induced by fraud and corruption. So they can stay the arbitration proceedings, which will not put the aggrieved party or the award debtor to unnecessary execution proceedings. Which, if he has a genuine ground of fraud and corruption, of course that will be considered at the time of final hearing of Section 34. But if the party can show a prima facie case that there was a fraud and corruption, the court can stay the enforcement of the arbitral award unconditionally. That situation was not there earlier. Earlier, the court had discretion, like Anupam said, the court had discretion to impose or ask the parties to deposit the amount of the arbitral award. Then the award will be stayed. Otherwise, the court did not stay the award. So by unconditional stay, the party who is aggrieved and who wants to take up the plea that the contract, the main contract wherein the arbitration clause is there, was itself induced by fraud and corruption, I have a right to stay. I have a right to seek a stay on that arbitration award, enforcement of the arbitration award.
Okay, great. We've got one question. I'll just run a quick question now, because I think it's relevant to what you're discussing, Kiran. Is from Kritika Mishra. Should the fraud corruption ground be raised at the first filing or only at the time of filing for stay?
So when Section 34 petition is filed after the arbitral award is passed, then this plea of fraud and corruption has to be taken at initial stages. So this amendment of 21 has a retrospective effect. Even if there are Section 34 petitions which are pending before the amendment came into picture, the parties still can take this plea of fraud and corruption by filing fresh interim applications to the Section 34 petition.
Okay. I just want to, Vikas, with your permission, I just want to add to what Kiran just now mentioned.
Sure.
So what Kritika is saying, that do I need to take the ground of fraud and corruption at the first instance when we file the appeal or at the time of stay? Really speaking, any ground that you take when you are in appeal can't be an afterthought. You know, a court of appeal is always sitting in a judgment of what was before the panel, that is the arbitration panel. Did they examine it in appropriate way, or was the evidence appropriately examined? So I would rather say that not only at the appeal, but if you are saying that the agreement, that is the arbitration agreement, or the contract, that is the underlying contract which is resulted into the arbitration, if it is vitiated by fraud or corruption, you should have taken that ground at the point of filing your claim for arbitration or your response. Because if you go in appeal and say that we want to take the ground of fraud and corruption for the arbitration agreement or arbitration contract, the appeal court is going to say, did you take that ground before the first authority, the trial authority, that is the arbitration panel? And if that ground is not taken, in my view, of course, the appeal court will be well within its right to say that we are not going to take up any new ground at this stage because we are an appeal court and we just have to see what evidence before the arbitration panel was examined properly or not. But there is one exception to this which I want to make, because as I mentioned, there are three things which are mentioned in the amendment. One is an agreement of arbitration. The second is the contract, and the third is the award. Now, I will not know that the award was vitiated by fraud or corruption when the award is passed. I will know only after the award is passed. Just to give a hypothetical example, if one of the panelists of the arbitration panel gets some of his relative gets a good contract after the award was passed, or if any of his relative gets a high post in one of the companies of the winning company, then the other side can say that, see, I smell a rat here. There is a quid pro quo in terms of the award that has been passed, and there is a fraud and corruption in respect of an award which I wouldn't have known at the time when I filed my claim. I can know about it only after the award is passed and the circumstances surrounding it. And that is the only point, according to me, which you can take for the first time when you go in appeal. And that also has to be taken at the first instance when you file the appeal. So to answer Kritika's question, the first 2 points about fraud and corruption in respect of agreement and the contract have to be taken even at the stage of the arbitration. You have to also agitate that point before the arbitrators to say that there is corruption and corruption as well as fraud for the agreement and contract. But when you're talking of an award, that is only possible after the award is passed. So that can be taken at the first instance when you file an appeal. And again, stay is only a interim application which you are making. So you have to take it in your main appeal under 34, and you can reproduce those grounds in your stay application when you file. Thanks, Vikas.
Great, thanks, Anupam. Thanks, Kiran. To the other attendees who are asking questions, we're going to come to them slightly later on because we're going to move over to Ajit now. So Ajit, in light of the deletion of the 8th schedule of the Principal Act, and moving over to what Anupam was saying before about accelerating the availability and pool of arbitrators that might enter India, do you think this change will facilitate the participation of eminent foreign nationals in Indian arbitrations as arbitrators?
Well, see, as I already said, this provision is quite progressive, and the previous legislation where it made restrictions on appointment of arbitration and qualification was defined, that was quite restrictive in terms of bringing foreign arbitrators. And as Anupam has already mentioned, at times one of the party is an overseas company, and they are quite comfortable having their arbitrators to come and contest the case. So this new amendment where they have omitted the qualification, that's quite progressive. India has got a bit of scarcity in terms of when it comes to arbitrators, especially cases are getting more and more complex, and that complexity has to be addressed with a lot of technical knowledge. Okay, now since we have got scarcity of good quality arbitrators, and I'm not saying in a bad way, just it has been like that. So when there's a scarcity and those arbitrators, and there was a limit on how much arbitration matters they can handle, they all were under severe pressure. There has been occasion when we had to instruct arbitrators in India. It was getting difficult because everybody was overbooked, oversubscribed, I would say. Now, because of this legislation, foreign arbitrators, they can participate. Those who have got technical knowledge, they can be part of it. And even if they don't tick all those boxes, which has been defined in the previous amendment. So it's quite progressive in a way. What is not happening, and it has been highlighted already, it has not been defined. A regulation will be drafted in future, what that regulation will look like, and what qualification will be drafted in that a regulation for the arbitrators. That's still a question mark. So again, government has to start doing some talking and explanation how those qualifications and what qualification will be, and sooner is better.
Yeah, yeah. And just from the point of view of foreign investors, because you work with a lot of foreign investors, foreign corporates who are interested in India, what impact do you think that amendment will have on the thought process and strategies of foreign investors?
I think everybody is quite happy about it, because now they are not restricted in choice of arbitrator. They can choose. Okay. Again, as I said, a bit of clarification from government is required, where they will say that what regulations will look like and what council. So as I said, it's on part of government to come up quickly with those regulations. Okay. Until that point, regulations are not there. There will be an element of uncertainty, and foreign investors, they don't like uncertainty. And if that continues for a very long time, that whole ease of doing business in India and rating and all that might slip a little bit. So it's on government now to come up with something.
Great. We've got a question, relevant one here to what we're talking about. Soham Banerjee, who's asking, do you believe that the concept of unconditional stay on grounds of fraud or corruption will inspire investor confidence in the enforcement regime of India? So I'll throw that to any one of you who wants to answer that.
So I'll just chip in here, Vikas. Answer to that is yes. There has always been an image of India that there are a lot of corruptions and things which are going on, but this is a strong message that has been sent from the legislature, that they do not tolerate fraud and corruption, which will take away the right of any person, and specifically making that as a ground for an unconditional stay will certainly show that there is a zero tolerance in respect of corruption as well as fraud when it comes to justice being done. And it will definitely be a positive development from investors, or for matter of any litigant for that matter, that he will not be fearful about that what happens if the other side, which is strong enough and capable of influencing certain people, and this is a tool that is available to them now.
Okay, great. So we're going to kind of move over to the kind of summary of what we think of, what the amendment means to the business sector. So Kiran, I'll go to you first. So how do you look at the overall amendment that's come in? Positive, negative, in the middle? And how can corporates and investors respond to the changes from a practical point of view?
Yeah, because every coin has two sides. So this amendment has positive sides as well as some negative sides as well. So positive sides, as we have discussed, that section amendment in the section 36(3) and even the deletion of 8th schedule, which will so foreign arbitrators can take part in the arbitration which are happening in India. So that is a positive side. A negative side can be talked about is that whosoever, a party who doesn't want to give a award to the award holder, then he can prolong the litigation by taking a plea of fraud and corruption, because the court just have to see the prima facie case which is being made out. So once that prima facie case is made out and the award is stayed unconditionally, then the matter may get prolonged for years and years. So the award holder may not get his due under the arbitration within a specified time. So that's my view on this.
So Ajit, I'll throw that over to you next in terms of, how do you, I know you've kind of said it's a progressive piece of legislation. There are always going to be pros and cons. The government has to do a bit more thinking about the practicalities, but what's your overall view on the amendment? how can corporates investors respond to the changes from a practical point of view? And what other kind of advice would you give to the government, if possible, in terms of fine-tuning it?
Well, I think overall the amendment is both good and bad news. Good news because now there's a possibility that if there's a fraud or corruption, it can be addressed in a defined way. Arbitrators, when you're choosing arbitrator, you can choose what you want. Okay, that's good news. Bad news is that it's not clearly defined. Okay, so as I said, those rules, regulations, or definition of what is a fraud or corruption, those things need to be defined properly. So from foreign investors' point of view, it's not uncertainty is always bad. It's always bad. They don't like uncertainty, and at some point, if these things are not defined properly and court is not giving a kind, it will correct over a period of time when there are precedents and all that. But overall, I would say it's both good and bad news from foreign investors' perspective.
Okay, super. So Anupam, that question back to you in terms of overall kind of point of view, positive, negative, and how can the business environment respond to the changes from a practical point of view?
Right. So the way that I would put it is that it is a positive step in the right direction by the legislature, and they have made their intention clear about what they want to achieve, which I mentioned. That one is that they want to have certainty. They want to reduce the discretion which is exercised by the judiciary, and they want to have a speedy disposal of the litigation which are going on. So this is a step forward towards those objectives to be achieved. But take what Kiran and Ajit just mentioned, it is a step taken, but not fully implemented in a way that it ought to have been done. Like Ajit mentioned that the amendment for the qualification of the arbitrators, it says that there will be regulations which will come up subsequently to say what the qualifications should be. But these regulations are not out yet. So look at a situation of a person who wants to appoint an arbitrator right now. If I'm a foreign entity and I look at the amendments as of today, and I say, yes, I can go ahead and appoint a foreign lawyer as my panelist on the arbitration, and say he's appointed, arbitration goes on for a month, 2 months, and subsequently the regulations come out and say that only an Indian can be an arbitrator in the arbitration. So where are you now? So those are the uncertainties which ought to have been answered. So my take would have been that if they wanted to take a step to clear out all the doubts, everything should have done at the same time. Keeping lingering aspect of regulations being done subsequently is again creating uncertainty. So the intention was right, but it was not implemented in a full manner. It ought to have been done.
Yeah. Great. We're going to now just answer we'll go to some of the questions other questions that have come up. We have another one from Soham Banerjee. How do you look at the debate surrounding Section 11A in light of the ACI? And do you see the standards of judicial review in respect to the appointment of arbitrators changing with the introduction of the Amendment Act? Kiran or Anupam?
Would like to take it, Kiran?
Vikas, I'm not clearly understood the question. Where is it heading?
Okay. So
whether they want to discuss Section 11 here, or what is ACI? So I'm not clear on the question.
Got it. So Soham, if you could clarify the question, or if you want to join us on the session to ask that in face-to-face, where that might be easier. Anupam, if you want to give it a stab in case you can.
Yeah, so basically we can do it offline once our session is done. So Soham can get back to us and we'll take it up.
Super.
So I see a few more questions ahead, so we can rather than discussing that, go forward.
Done. So the next one from Jagdish Shidke: should not the aggrieved party also file the FIR to strengthen their stand?
Yeah.
What be your viewpoint on that?
Yeah, they can file the FIR to strengthen their stand, but the police authorities won't have jurisdiction to set aside the award. So this is a little bit uncertainty in terms of what the Section 34 court can travel beyond its jurisdiction to consider the fraud and corruption, because that's a criminal matter altogether. So whether the Section 34 court is going to sit in a criminal jurisdiction and decide what kind of fraud that has occurred, or what kind of corruption that has occurred, or whether the fraud which has been occurred is falling under the definition of a fraud and corruption. So that this is little bit of uncertainty in terms of fraud and corruption being taken as a prima facie ground to stay the award. But yes, of course, the parties can very well file an FIR to strengthen their case, but this will not help them at the initial stages when the award is stayed. But this will be definitely considered. The court will have to give their opinions on this while hearing the Section 34 petitions finally, whether the FIR filed will strengthen their case, and whether the proceedings pursuant to the FIR filed has any impact on the Section 34 petitions which is being heard.
I got it. So we've got another question, next question from Anonymous, but how will the retrospective application of the amendment impact ongoing arbitrations or stay applications?
So I'll take up this question with the permission.
Sure.
So the impact of a retrospectivity is that already our Indian courts are burdened with so many cases, and if Section 21, the amendment of 2021 has been given a retrospective effect for the arbitration which are pending even prior to Section amendment of 2015. This will the court will burden with more applications with the ground of corruption and fraud. So I'll just read the question again. So definitely the courts will be overburdened if the litigating parties wants to prolong the litigation. So they will definitely file this interim application even at the Supreme Court stage to take up the matter. And if the award is stayed unconditionally stayed at the initial stages, then the matter will prolong for another years.
Got it. Okay.
So just to add here to what Kiran has already said, is that whenever there is a retrospective amendment, as in the present case, it is always what the courts look at is what are the actions that have been already taken. If the actions which have already been taken are in alignment with whatever in existence at the time of taking of that action, then it will not vitiate that action just because there is a retrospective amendment. Also, retrospective amendments are always in the nature of clarification than changing the whole act around it. And we've had these issues quite a bit, typically in tax litigation, where if a retrospective tax is being imposed, then that impact of that on the assessee happens only provided he could have been reasonably been aware that this is what he needs to do. You can't make somebody do something which he was not aware when a particular action was done, an award was passed, or certain appeals were done. So that could be one of the points which we can always raise if somebody is trying to use these retrospective amendments to prolong the matter and make frivolous applications just for the sake of delaying the whole process. Of course, but whichever are pending litigations or whichever are pending appeals, you will always have a right to take up these as grounds before the finality is attained in respect of those decisions.
Got it. We have the next question we have from Tejas Parekh. If prima facie there exists a fraud, corruption of a contract, how can that be brought forward to the arbitrators, whether by way of Section 17 application, but the arbitrator rules against it, can it be appealed?
So, as the proviso, which is very clear that the award will be stayed if the contract and the arbitration application was induced by fraud and corruption. So the legislature needs to amend the section 16, which says that even if the arbitration agreement is distinct from the main contract, and even if the contract is null and void, still we can go ahead with the arbitration and pass an award. But to answer Mr. Parekh's question, you can't really take that ground before the arbitrator, because the arbitrator will have no jurisdiction to decide on that when there is a specific proviso added in terms of enforcement of the arbitral award. So even if the arbitrator go ahead and passes an award, then you have a ground to challenge that award under section 36(3). As Anupam said, that parties will have to take the early recourse to the defenses available to them. So the parties, of course, will have a right to take up this ground that the arbitration agreement and the contract is induced by fraud and corruption. But in my view, the arbitrator will not decide on that question.
So what Kiran is trying to say is that the amendment which has come in is more towards the appeal provisions and the stay pertaining to the appeal. So it doesn't change anything as regards the proceedings which were carried out before the arbitrator. And earlier answering to earlier question, that the grounds have to be taken in the arbitration. You can also make it as a preliminary ground, but whether the agreement was vitiated by fraud or corruption can be only determined only after leading evidence. So section, you can't do an interim application under section 17 before the arbitrator to say that give a prima facie view about the contract or the agreement being vitiated by fraud or corruption. Just to put in summarize the thing, the amendments talk of fraud and corruption, which specifically relate to a stay which is in respect of the appeal proceedings which are before the High Court. Section 17, which is an interim application to be done before the arbitrator. There is no change that has happened in the law, so therefore the same process will continue. Since it is the first court of trial, the arbitrators are the ones who have to first lead the evidence and then appreciate the evidence. They cannot come to a prima facie view because there is no evidence at all. Whereas the courts can come to a prima facie view because there is already evidence available to them which was led before the tribunal. So there cannot be an interim application to say that the contract is vitiated by fraud or corruption unless they assess the evidence. So section 17 won't be available to say that agreement and the contracts are vitiated by fraud and corruption. It has to be at the end of the arbitration award after the evidence is led. The amendment talks of if based on the evidence which was there before the arbitration panel, the courts are of a prima facie view that yes, there was fraud and corruption, then they have a right, or they have a duty, because it says shall. They shall mandatorily and unconditionally stay the award.
Next question we have from Aman, which is more about section 42A. What's the interpretation of using the word inspection? Well, we can go line by line. There's 3 different points inside his main question.
I think this is because this will require a lot of explanation, and this is slightly away from our topic right now about these specific amendments. So we'll happy to help Aman offline on these, because we'll need to give him proper explanation on this.
Sure. So we'll skip to
we'll stick to specific amendment related questions, because I know arbitration is something which is a very interesting topic, and people do have questions apart from the today's topic, which we are specifically restricting to the amendments. And we can of course have offline sessions with any of these people who are attending in terms of any questions they have. More than happy to answer their queries.
Great. And what we'll do anyway post the session is connect the panel, the panelists, to the attendees, so that you could have these offline conversations. I think Soham's will probably be the next relevant one we could ask in terms of, in short, whether the standard of judicial review in Section 11 applications will undergo any change with the introduction of ACI and the subsequent deletion of 11.6a. She's clarifying her earlier question.
Yeah. So now Section 11 jurisdiction is very much clear. The courts really can't go into the validity of the agreement. The court is bound to, the court is restricted rather to see whether there is an arbitration agreement or not. If there is an arbitration agreement in the main contract, then they are bound to refer the matter to the arbitration, and they have to appoint an arbitrator as per the arbitration agreement. So I understand Soham's question coming from whether the court can take up the prima facie view in Section 11 itself, whether that agreement and the contract is induced by fraud, and the court should not appoint an arbitrator based on that contract, which is induced by fraud and corruption. So, like Anupam said, the proceedings under Section 36(3) are in appeal proceedings. The proviso and the amendment talks about when the matter is in appeal court. So, therefore, the situation and situation under Section 11 will not change. So, if there is if the party thinks that the contract is induced by fraud and corruption, then they have a right to go to the civil court to resign that contract, because that contract itself is void at first place. So therefore, there is no requirement of a party to go to the court for an appointment of an arbitrator. Even though that ground is taken in Section 11, nowadays the situation is that Section 11 is unchanged, and the the court cannot go into the validity of the agreement. The court will not look into the fraud and corruption aspect of that agreement. So therefore, even if that stand is to be taken, that has to be taken at the appeal stage. If the court goes ahead and appoints an arbitrator and the arbitration proceedings go ahead.
So just to add to Kiran's point, the question which I answered relating to Section 17, same way, the fraud or corruption, though are very serious allegations, they can't be decided in a trial, or they can't be decided unless evidence is led. The amendment that has come is in respect of appeal, where the appeal court already has the benefit of evidence that has been led before the arbitration panel, and therefore they can come to a prima facie view. But in absence of any evidence that has been led before these preliminary applications which have been made, like Section 9, Section 11, Section 17, in absence of any evidence, it will not be possible for either the courts or the arbitrators to come to a conclusion that there is fraud or there is corruption in the matter.
That was interesting. So apologies there. There was a technical issue. We'll go back to, sorry, I just missed that last point. So Kiran managed to answer Soham's question, did he?
Yes. Myself and Anupam also.
Great. So I think we've kind of answered all the relevant questions for today. What I want to do is I want to wrap up today's session. I want to thank you to all the panelists, Ajit, Anupam, Kiran, for a very informative session on what is a very contentious issue for the business environment today. You really helped decipher some of the grey areas around the amendment. And while those grey areas will still continue until we have kind of further clarification from the government, we've kind of given a good, a better understanding to the attendees of what impact that will have on the arbitration environment in India. Thank you also to the attendees for tuning in and asking thoughtful questions to help clarify some of the challenges brought up by the recent amendment. We'll be circulating today's session to each of you post the event to share with your team. And I'll also connect you to our panelists to discuss some of the changes in a more one-to-one offline conversation. So I really want to thank all of you for
Thanks,
a
Vikas.
great session, very informative, not easy to kind of dissect, what the government's trying to do here. But thank you for, a great attempt in clarifying some of the challenges.
Thank you
Thanks,
so much.
everyone.
Thanks,
Thank you so much.
Vikas. Thank you very much for doing this session.
Thank you so
Thanks,
much.
Vikas.
Pleasure.
Thank you, everyone. Thank you.
Yeah.
Thank you, everyone.
Thanks. Bye.
Bye.
Bye.